excuse me, it's in bold print here. This is supposed to stand out and say, look, buyer and seller, presumably you're over the age of 18, because if you were of the age minority, you couldn't sign this contract anyway. So you're over 18, you're legally responsible for your decisions. You are signing this agreement saying that you have read it and that you agree to all the terms that are contained herein. That's a pretty big statement. And also, there are things that I, the broker or an agent, can't tell you about. I can't speak to things that may be a legal aspect outside of my scope of training and licensure. I can't talk to you about your taxes and what you should be doing there. I'm not an insurance expert. All those things are disclosed here that I'm not providing that service to you. The rest of these have to do with other disclosures we wanted to make in the contract. So paragraph A, property condition. This is to let you know that there are home warranties and inspection services available. You, the buyer, should avail yourselves of them. That the broker cannot give you information about water and quality control, sewer, septic, flood zones. All that's outside of our scope. We will refer to you to people who will talk about zoning, subdivision rules, environmental laws, and the rest. And let me also say this paragraph A, has certainly covered the backside of many an agent. It is a common practice for unfortunate reasons, basically just that's always been our history and no one's really thought it through, that we tend to speak well outside of our scope about things. So when the buyer says, can I have horses? We go, sure, as long as you have no more than 3, if you have 3 acres, you can have 1 horse, 1 additional acre per horse. That is true in only certain counties, and that is true for only certain zoning types. It is not the standard throughout. If a buyer has a question about were permits gathered, is this properly permitted, is the septic system okay, can I have horses, you should provide the phone number. And if anything, conference call your client in with the right person to give that advice, or let them make the initiative to reach out that way. If you get in the middle and you start making calls and come back with information about things outside of your scope or the standard here, you've started to accumulate the liability for that advice. So for example, if I'm a buyer and I call the county and go, it looks like there's no permits in the basement, the buyer doesn't stop there. The buyer goes, what does that mean? What's next? How do I get permitted? Why not let the buyer have that conversation with the county to explore what they would consider a issue for them on their own property? And it goes on to say that we are not experts to tell you about FRT or radon or polybutylene or any of these other things. That does not relieve you of the responsibility of understanding what they are and disclosing them if you know they exist. That is simply stating that I don't have an obligation to tell you about things or give you detail or information about what can happen in the future on those elements that I'm not a specialist in, lead-based paint and all the rest. I still have to disclose it if I know it's there, but I don't have to know the science behind it to know it's there to disclose it. Paragraph B under 31 is about all contracts have to be in writing. This is actually heralded from the Statute of Frauds, which was established in 1677. This is nothing new. This is law that's also been rendered as a disclosure in the contract. Remember, all of paragraph 31 is simply putting in layman's term for your buyer or seller what is already in the law as a protection. We're not establishing anything new. We're letting the buyer and seller know, hey, here are some realities, and we're putting it here so that you aren't surprised by them later, so you don't have to go read all the law to understand. But paragraph B says everything has to be in writing to be enforceable, which is actually established elsewhere too. This is a disclosure to buyers that, you know what, you can lock in whatever you want to do, but we can't control mortgage rates. We're not promising anything in the future. This is up to the loan officer. You and the lender need to talk about the details of your loan. We aren't the experts in that. We don't know every loan program, and you should seek your own advice on that. Excuse me. This is a reminder to buyers and sellers that our job is to be the real estate agent. We're not, again, attorneys, tax advisors, lenders, appraisers, surveyors, structural engineers, etc. We are only working within our frame of reference. It goes on to say that from time to time, our brokerage or company may have relationships with title companies or settlement companies or lenders or home warranty companies, and we will disclose those times where there is a potential conflict or there's a relationship. Paragraph E, we can't control property taxes. They probably will go up. We aren't promising anything about the future. Again, the lender is going to require property insurance. If you're paying cash, you should still get insurance. And you should check it out early because You never know what's going on with the property. It could be hard to get. This is a disclosure to the buyers that the lender is going to require them to get title insurance to protect the lender. That doesn't protect the buyer. It is a separate policy if the buyer wants to get it, and it is not required. The second part of the paragraph says that the purchase of title insurance is either standard or enhanced, and that they should check with their lender and the settlement company to understand the difference between the two, that we're not going to be the ones to give them advice on that. Paragraph 32 is assignability. The contract can be assigned, cannot be assigned to any other party. In other words, I can't, and believe it or not, buyers have tried this. You know what, I don't want to buy this house anymore, but my brother's looking. He likes this house. He likes the terms I negotiated. We'll just have him get involved and do it. It doesn't work that way. So your client, the only time that assignability is actually even a thing is generally for VA anyways, and that's for loans or assignable. The contract is never assignable. I can't just have someone jump in there and take my place. If someone else wants it and I'm getting out, they need to contract with the seller directly, and the seller needs to grant me a release based on whatever they're working out. I've never seen that done, but that is the option. Paragraph 33 is a bunch of miscellaneous definitions. As I said, there are areas in the contract that have capitalization or are addressed later on or have a very specific meaning, and this is a quick outline of what they are. So date of ratification is the date of delivery of the final acceptance. So we tend to go in and write the ratification date right there, and that generally needs to come from the person who last receives an executed document. So you and I are going back and forth as buyer and seller, and the buyers have finally said, we agree to all the stuff the seller has countered with, we're good. You give it back to the seller, the seller's agent then puts in the date and sends just maybe that page back or the whole contract, either one's fine, showing that we agree. This is the date that we all came to agreement, and all the clocks start tomorrow morning at 9 a.m. Appraisal is a written valuation of the property. Days are calendar days, which is a pretty important thing to remember. There are specific times in the contract where business days are specified, like the deposit of the escrow and a couple other places. Anywhere else that days are mentioned, it is calendar days unless specified as business days. Everything is Eastern Standard Time. In case your clients are out of the area and you say 9 o'clock, it's not 9 o'clock when they're in California, it's 9 o'clock Eastern Time. And again, as I just mentioned, paragraph E, or subparagraph E, says for the purpose of time periods, a day is going to start the day after delivery. So if I deliver today at 8:59 p.m., tomorrow starts my next day. If tomorrow I deliver at 10 a.m., the next day at 9 a.m. is the first day. Delivery has a whole paragraph on the delivery. Specified financing is in specified financing. Anywhere they say man, it also means woman. Possession date is in that paragraph. Legal expenses are defined as the attorney fees, court costs, litigation costs, any other costs limited to your legal experience with them. Notices we have defined elsewhere. Notices are unilateral. So notice means I am just telling you. So in placing a contract, it says buyer shall deliver seller a notice. That document is only to be signed by the person delivering it. It doesn't have to be signed as received or agreed to by the other party, because unilateral will say I'm telling you. It's not saying I need you to agree or capitulate. And again, buyer and purchaser may be used in here. It means the same thing. Paragraph 34 simply says that this contract, even if it's not everybody giving wet signatures or the same document, if we make corrections and send it out by fax or scan or whatever, it is still the core contract. Whatever is signed is merged into the existing agreement. If it's altered or changed, it's merged in. I don't have to have one solid document that was signed all at the same time. It also says, and this is just simply to reiterate what the law is, anything that's typewritten or handwritten will be superseded or will supersede pre-printed. So if there's a conflict, if you've handwritten stuff in there, I can't go back and say, well, the contract said this before you changed it. Whatever you have typed in or written in these dynamic fields supersedes pre-printed stuff if there's a conflict. Be very careful how and what you write. And again, not a whole lot of freehand stuff in the core contract. It's the addendums and other special agreements we get into that gets ugly and gets some fancy and weird stuff in the language. We'll talk about that later on. Void contract, if the contract becomes void and not forced in effect without default, both parties will immediately execute a release. So paragraph 35 says, this is compelling your seller. For more or less, it may be both ways, but for the most part, what this means is, I, the buyer, I'm letting you know I'm getting out on a home inspection. Boom. I did it my time frame. There's no question of whether or not I was in compliance with it. This says, look, if the seller doesn't sign giving a release, they may be in default of the contract. They can't drag their feet. They can't ignore it. They shouldn't let it go an unreasonable amount of time. And we have to... There is no, you must execute in 48 hours. It's what's reasonable. If in 2 days the seller has not taken some action to move towards a release or enforcement of the contract, that may be unreasonable. So in other words, your seller says, you know what, I want time to think about this. Well, you better be talking to an attorney, at least to be registered as having talked to an attorney, because just sitting here not doing anything is depriving the buyer of money they are probably rightfully due, and that could put you in default of the contract, Mr. Seller. So whereas the buyer wasn't, while you're trying to simply be punitive and harm the buyer for not buying your house, you may actually be damaging yourself and opening yourself to liability. So there should be strong encouragement for you, if it's clear the buyer had the right to get out and the seller's just like, meh, he can wait, to really force, or not force, but encourage that seller to perform so the buyer doesn't start getting attorneys involved and get angry and lawsuits and all the rest. All right, paragraph 36, home warranty. Whew. Home warranty seems so innocuous and so simple, but it really rather isn't. So the home warranty is going to be a service or a policy that's going to be placed generally by the seller. Most home warranties protect the seller from the time of listing to the time of closing. And this home warranty paragraph says, is there going to be one? Yes or no? So let's say there's yes. The home warranty policy will be selected by the buyer and seller and paid for and provided at settlement by buyer or seller. So there's two different parts here. Who gets to choose it? Who's going to pay for it? And then there's this area that says, okay, what's the cost? Now, let me go back to what I said at the beginning of this series. Now, we're going to break up these paragraphs in different videos, so please don't start here at paragraph 36 when really you should have started at paragraph 1. But the contract cannot have things that are unanswered. You can't put to be determined for the settlement company or to be determined for the home warranty company, because the contract is a meeting of the minds. It's an agreement of the parties. So your buyer and seller need to agree as part of the ratification process as to what home warranty company they're going to get. So let's start there. Let's say they've agreed to AHS, or Coldwell Banker Home Warranty. The next step is to agree on how much that policy is going to cost and who's going to pay for it. So let's say it's a $675 home warranty and the seller says, I'm paying for it, I got this. You can simply put that in the contract. What a lot of sellers will do, and maybe their agents, will say, let's go find the least expensive version of the AHS home warranty. And let's say, and I don't know this real number, let's say it's $550. They get the $550 policy, the seller sees it and says, no, there's another $120 here that I want to spend. I want the pool coverage. I know you ain't got a pool, but I want the coverage, and you agreed to $675. The seller more likely needs to pay for the $675. But why do we want any of this ambiguity? Why do we want any of this nonsense? Go grab the home warranty application from whatever home warranty the buyer and seller have agreed to. Fill it out as part of the ratification process. Get the buyer and seller to initial the home warranty application saying that's what we've agreed to. The seller's going to pay for it. The seller's going to order it. It'll be delivered at closing. And this is how much it's going to cost, and here are the protections permitted in it. Now you don't have any ambiguities and no conflict and nothing to bicker about at the closing table. You did it here during the honeymoon phase when buyer and seller are in agreement that they want to buy and sell the house. So when you get to this paragraph, don't be lazy here. But to be determined, which means nothing other than you probably have a problem later. Go grab the application and just send it over for initials so the parties know what they're getting. But generally what you're going to see is home warranty, yes. The seller will often pay for it. The seller's often going to choose it because they pay for it. The fee will be whatever the fee is for that home warranty that the parties agreed to, and it's going to be AHS home warranty. I have no idea why I'm typing in all caps. Don't make that a habit. Use proper capitalization. It's just whatever. All right. Paragraph 27. 37.